In Indiana generally, with personal injury claims, the way it works, if you do go to a jury trial, we request that the jury make a certain award to you for the amount of your damages sustained. After the jury determines the amount of your damages, the jury has to apportion fault for the accident. Their fault apportionment must add up to 100%. If the jury awards you a damage award, it's a terrible day. We're just going to estimate they award you $1,000 in damages from your accident. However, the jury determines fault for the accident. 80% fault is on the defendant and 20% of the fault is on the plaintiff's action or failure to act. That 20% fault apportionment would directly reduce your damage award by 20% from the $1,000 to $800. However, it's called modified comparative fault in Indiana because if the jury were to determine that the plaintiff is actually more at fault for the accident than the defendant, any amount more, if the plaintiff is 50.0001% at fault for the accident, then the plaintiff cannot recover at all in Indiana. That is why it is modified comparative fault as opposed to pure comparative fault. Now, there are also certain situations, though they're rarer, whereby you cannot recover if you were partially at fault for the accident. This goes back to situations involving government sub-entities. If you are involved in an accident with a government sub-entity, then generally contributory negligence will apply to the case as opposed to modified comparative fault. And contributory negligence means if you contributed to the accident in any manner, then you're barred from recovery. So while that is more rare, generally modified comparative fault is what's at play on our personal injury claims. And generally, you can still recover even if you are found a portion at fault for the accident. However, it will reduce your recovery.